May I please?
Yes.
Your Lordship, item number 25, 26, 27. I'm entering for 25 and 27.
Hmm.
Your Lordship, we were supposed to file an affidavit. Though prepared, though vetted and everything, we find there's some mistake that we need to take steps to rectify.
Okay. Okay.
Can I pray for 10th of January? I pray the consent of the site.
10th of January.
That's
Fine.
what I need to say.
On the prayer made by Mr. D. Senapati, learned counsel appearing for
Respondent number 4 and 5.
respondents number 4 and 5, comma, not objected to by the learned counsel for the petitioners, comma, registry to list this matters again on 10/1/2020, 10/1/2025. So, the learned counsel for the respondent has further submitted that the affidavit in the matter would be filed immediately on reopening of the court. So, 25, 26, 27.
Much obliged.
May I please, Your Lordship? I have taken the consent issue. Item number 5, Your Lordship. We need to file affidavit in reply. Kindly, this matter may also be taken up on 10th of January.
On the prayer of the learned counsel for the appellant, raised item number 5, madam, raised to list this matters again on 10/1/2025.
Deeply obliged, Your Lordship.
Yes.
Lordship, I beg to mention item number 17.
7?
17. Your Lordship, due to unfortunate circumstances, the Karnataka Council A Tatak is not present today.
Wait. What is the unfortunate circumstance?
That I was not informed.
Huh?
I was not informed.
So, what is left here? Nothing is here.
We have to file the affidavit in reply. For that,
Fine.
we
If
need
you
time.
find an affidavit in reply, what
Yes,
change
for that,
can you bring?
We may be given 2 weeks of time.
Interlocutory order. Rightly, this court vacated the interim orders. Right? That's the case. And even if we go on merits, what is the Kabang decision? It's not a Kabang decision.
Your Lordship,
Okay, fine. When do you want it?
After 2 weeks, Your Lordship.
On the prayer of Mr. A. Tatak, learned, prayer made on behalf of Mr. A. Tatak, learned counsel for the petitioner, comma, not objected to by Mr. O. Modi, learned counsel appearing for the sole respondent, comma, registry to list this matters after 3 weeks on a date to be fixed by. Trial is proceeding?
Yes.
Go ahead.
Lordship.
May I please, Lordship? Lordship, I beg to mention a pending bail matter, Lordship. Kindly, it may be taken up today just for withdrawal. I want to withdraw. God bless, Lordship.
May it please, Lordship, pertaining to item number 14, Lordship, the arguing counsel had instructed me to ask for adjournment since he lives in Guwahati and it's difficult to come on today. Lordship.
Has the accused recorded his statement?
Yes.
Recorded.
Yes.
You be here. We'll not pass anything order. Let's see what happens. We'll hear the PP, then pass orders.
Much obliged.
May I please, madam? Madam, I beg to mention item number 6, madam. I am both respondent. In here, madam, the parties are agreed to solve the matter outside the court, madam. So,
What is left here?
sometime may be given, madam.
What is left here after the second amendment? With regard to the first amendment, both parties must agree to go before the larger cabal, inter-district cabal.
Yes.
Now that has also been amended. Says that if you have a grievance, you can go. Agreement is not required. So after that, if you have any grievance, go up. And that second cabal has not taken place. Has it taken place?
No.
Then,
Madam, since they are ready to, if they accept that, we will withdraw the message. So, this change them.
on the prayer made by Mr.
M. Doji, madam, on behalf of T-Time.
On the prayer made on behalf of Mr. P. Tyne, learned counsel for the respondents, and it being submitted that a move is on for reaching an out-of-court settlement in the matter by and between the parties, comma, which is not disputed to by Mr. O. Modi, learned counsel for the petitioner, raised it to list these matters after 4 weeks on a date to be fixed by.
Obliged.
Lordship, I beg to mention that
Pull it down, huh? Linda,
Your Lordship, I would like to mention the item number 28, Your Honor. Your Lordship, leading counsel for the petitioner is Your Honor suffering from fever, Your Honor.
Okay.
And
On the prayer made on behalf of the learned counsel for the appellant, raised it to list this matters again after 3 weeks, only 2 weeks by.
oblige, Your Honor.
Mr. Zammo is not keeping well.
Your Honor, N. Sharma, Your Honor.
Okay, fine. Any more mention, Mr. Kato?
My lord, I am submitting, my lord, the written submission in that criminal petition. Criminal petition on the last occasion, my lord, lordship is already filed.
Which criminal?
Criminal petition number.
What is the issue?
Issue, my lord, that sample collected by the Union of India, my lord.
That is there, I think tomorrow.
Tomorrow, my lord.
Tomorrow, okay, fine. Give it to her.
Replayable.
Because whatever criminal petition I had finished dictating. So I thought what it is. Okay, fine. Bulai. It's always pleasant to start off with Mr. Purkhaisto.
Because, my lord, I have my commitment, my lord.
I know that. Mr. Purkhaisto makes a commitment, he follows it.
In spite of my hand fracture, my lord.
Oh, ma.
Yesterday, I
You could have come online. I told you to come online.
no, yesterday, my lord, in the hotel, my lord.
It might be better for you to come physically. That's a different thing, but you could have come online also.
Other days, my lord, we could not get any link, my lord.
These days links are a bit problematic. Yesterday also I could not. Okay. You are ready?
My lord.
Yes.
So in this case, my lord, lordship has put a question.
Huh.
So what is the locus standi?
Forget the locus standi.
And
I accept your locus standi.
if I have the locus standi, then
You are in representative capacity. Let us accept that.
my,
What is your grievance?
my
Promotion.
but basically I have got two grievances.
Hmm.
Although lot of prayers are there.
Mm.
Number one, my lord, we being the incumbent of BO,
Mm.
whether we are eligible to get promotion to the next higher post.
So what is BU?
BO means block elementary.
Education officer. Now, you are not a teacher.
I'm not a teacher.
No. The BU is not a teacher.
The BO is not a teacher.
Then how come he is a member of this association?
No, the association is formed, my lord, both for school teacher as well as the BO.
Okay, both included.
So there are four I have met.
Okay. Now you want that the BO must be given an opening for promotion to the post of Deputy Director,
Director,
District
elementary education.
Elementary Education.
Therefore, the basic question I wrote, my lord, but we raised in earlier discussion as well as in this petition. Number of posts were sanctioned by the government. There are two heads number, my lord, heads of account, it is relevant. Heads of account 76 and heads
We'll
of
come
account-
to that. We'll come to that.
Therefore, my lord,
Now they have a rule, right? They have a rule of 2010.
that was prior to bifurcation.
No, forget it. Therein,
Bifurcation.
therein, see the stand taken by the authorities in the proceeding is,
It is a policy decision.
no, not on that. They say there are two directorates bifurcated in the state level.
My lord.
But insofar as the district is concerned, a deputy director looks after the primary as well as the secondary. And there is no dispute to that in your replies also.
My lord.
Secondly, this rule is continuing to hold the field, that is rules of 2010, wherein the post of deputy director of school education is to be promoted from the principals of government higher secondary schools.
That was prior to, my lord.
Be that as it may, even after the bifurcation, they have not given up. They say this is the rule that is holding the
My
field.
lord. Okay, can you
Right.
appreciate?
My lord, just one clarification.
One clarification.
My lord, earlier, my lord, subsequently, that rule has been amended. That was not brought to my notice. That's why we could not reply. 2014 amendment was done, my lord, in which for the HMBP, my lord, there's headmaster and vice principal, my lord. That is both principal and deputy director school education, same post, my lord. And the promotional post is, my lord, HMBP, my lord, headmaster and vice principal. Is the feeder post for promotion to the post of deputy director.
There was an amendment.
Amendment was there.
So, but this is not there anywhere in your records.
My lord, that's why, my lord, subsequently, my lord.
Give a copy to Mr. Purkaisto.
My lord, the amended
This is
part.
not an amendment, this is.
My
the
lord,
new
last,
rule.
just mark one, my lord. Amendment 2014, my lord. Rule 55 has been amended, substituted, my lord. 90% from HMBP and 10% from District Adult Education Officer, my lord. By way of amendment, my lord, that Rule 55, clause B and 6, 5 and 6 has been substituted, my lord.
So, Mr. Purkaisto, this challenge will again not be maintainable because there is a specific rule for recruitment to the post of Deputy Director of School Education. And that is the rules of 2010, which has now been amended
2014.
14. So if this be so, you present the challenge to these rules.
Hello, can we appreciate one thing, madam?
Hmm.
Initially, my lord, in 2013, my lord, some, my lord, clarification and recommendation was sought for from my lord.
Whatever executive action taken, if taken in violation of the rules, that is a nullity.
But my lord, whether
What relief can I give you in this petition when there is no challenge?
once,
You only have to shift the court from here to court number 1. That's all.
we appreciate, my lord. So once the decision is taken by the central government, the bureau is the feeder post for the next higher post of DDEE.
Where is that decision?
Yes. Can you see, my lord?
In that case, also this rule has to be challenged.
What is this?
Hello, kindly come to my lord, clause 16.
No, what is this?
This is the, my lord, recommendation made by
Recommendations are recommendations.
Department of Education Administration, National University of Education.
You do one thing. You bring this, challenge this rule, bring this, we will consider.
Then,
But now that there is a 309 rule holding the field, how can I ignore that?
that motivation, my lord, amendment was made, but they never brought it on record. Number
Be
one.
that as it may.
Number two, my lord, at the present position is that, my lord, the minister has put up the matter. Direct action is given to the department to put up.
Fine,
the matter.
minister can do, the executive has the power. We don't have the power.
No, minister is a portfolio, my lord. He might have some, my lord, some access. He can look into the matter.
That you approach any authority you want. As far as the legal issue is, I am saying because of these two things, my hands are tied.
Because of amendment.
Amendment and the rule, specific rule. Deputy Director of School Education, Principal, Higher Secondary Schools, Recruitment Rules 2010. And that has been now amended.
The Lordship, kindly, my lord, I can understand, my lord, anxiety of the court, my lord. The Lordship, kindly give me at least some more time so that I can consult the matter, my lord.
What?
And
change?
my lord, whether they are willing to, my lord, make an.
I'll pass an order, don't worry.
My lord, but if the rule is amended.
Because this petition will not be maintainable. We will have to file a fresh one presenting a challenge. You do that, we give you liberty. Okay, we'll take it up after some time.
They have made this amendment behind what?
No. Mr. Purkaisto, because it was you that I did not. Mr. Purkaisto, if it was somebody else, I would have dismissed the matter that day only. But it was you told me you wanted to look. I said, okay, fine.
After some time.
Yeah.
May I, Your Lordship? Your Lordship, on the last occasion, this Honorable Court has directed this petitioner to be present before London Trial Court, Your Lordship. And the same, he was present on 13th of this month, Your Lordship.
Bail granted.
And then we have also filed an application. So interim is granted, Your Lordship, till for the next date, Your Lordship. However, we couldn't get the order copy, CTC copy.
So what is left here? Nothing.
Yes,
You
sir.
continue to practice, you withdraw this.
Yes, Your Lordship.
Mr.
Jay Singh.
So and so, learned counsel appearing for the petitioner submits that in terms of the directions passed by this court, while order dated 4/12/2024, the petitioner had appeared before the trial court on 13/12/2024 and had also filed an application for bail. Also, it is submitted by the learned counsel for the petition that an interim bail has been granted in the matter to the petitioner till the next date fixed in the trial,
Yes, Your Lordship.
right?
Yes.
First off, in the above view of the matter, the learned counsel for the petitioner prays that he be permitted to withdraw the present criminal petition. First off, criminal petition with an criminal petition. First off, anything more to be added?
Nothing such.
Miss T. Ginny, learned additional public prosecutor who appears for the state has not objected to the prayer made by the learned counsel for the petitioner. In view of the above position, the present criminal petition stands dismissed on being withdrawn.
Highly honored.
Yes, madam, any instruction? Yes.
Your Lordship, the petitioner is saying that no work was pursued with the petitioner, Your Lordship. And also saying that secondly, the building or for the construction of building, Your Lordship, type 4 for J constructed by the petitioner should not be released due to paucity of fund.
Okay. Just give me your instruction. Your candid enterprises.
Yes, madam. No, Tawaba. Candid enterprise.
In terms of the directions passed by this court, while order dated 11/12/2024, Ms. Pangu has placed on record the instructions so received by her from the Office of the Executive Engineer, Doimuk Division, Executive Engineer, PWD, Doimuk Division. Also, a perusal of the said instructions would go to reveal that the claim so made by the petitioner herein is not admitted. Also, in the above view of the matter, this case cannot be disposed of basing on the said instructions. Also, accordingly, also, subpara, issue notice. Accordingly, issue notice. Ms. Pangu accepts notice on behalf of Madam.
1, 2, 3, and 4, Your Lordship.
1, 2, accepts notice on behalf of all the respondents. No formal notice need be sent. However, extra copies of the petition be furnished to the learned government advocate within a period of within 2 working days from today. Raised it to list this matter again after 4 weeks. In the meanwhile, the respondents shall file an affidavit in the matter. Affidavit shall file their response in the matter. Full stop. You can take back your instructions. 4 weeks.
Obliged.
Yes, have you got it?
No.
What is the great thing there?
The second page. Second page.
How? How is this done?
Since it's been done, Lordship, more on Lordship, just humanitarian ground Lordship, then RR following RR.
Do it for
Maybe they take a
Do it
human
for
for
him
me
also.
also.
And there is that since he was working in the earlier department as a casual labor, these people Lordship, who have been given this regularization, they are working in the department on this existing vacancy. That's
Whether
all-
that can be regularized.
That I understood, but just I'm
You are paying for the private respondents.
Yes, my
What
lord.
is you have to say?
My lord,
How to save your regularization?
my humble prayer is that not to set aside the orders because this is the only source to sustain my family.
See, by giving it to you,
Yes.
they have also denied the same benefit to many others. If it was put up for open recruitment, some other poor person would also have come in. At least you have even if we set aside, we will not set aside your temporary engagement.
Yes, yes.
Your temporary engagement will continue, but this regularization will go. We will direct that it should be put up for direct recruitment and thereafter participate. Whoever is eligible, appoint. But we will make it clear that your temporary engagement prior to this will be restored to you. Will do?
Plus,
See, this can't be done.
moreover,
The last, for dismissing Mr. Punning's petition, the last resort was this. I thought something material will come here, so I'll dismiss his petition. Now I can't. I'm stuck.
then, my lord, we will go with the submission made by the government side then.
What?
Whatever submission made by the government side and
My lord, one thing, if your lordship restores their temporary service, what they have done is they are giving them the salary of regular employees because they have been appointed as ad hoc.
Be that as it, whatever it is there, that is there. Will not go that. Your only thing is with regard to their regularization.
Yes.
We will interfere with that, direct the posts to be put up for regular recruitment, and then because they have a rule.
Yes, yes.
The rule also says it
Direct
should be 100. Yes, Mr. You have a rule also, 100%. 100% right? Operation successful, but patient, but no benefit.
I thought in this last 5 years.
The process is completed.
They
That
will
already
continue on ad hoc basis.
No.
I'm not interfering with that.
No.
Why not they put a time frame on the advertisement?
No. Your thing is done. That's why I said. Operation successful.
In fact, my lord, the state should be thinking about this. Because they are paying them, my lord, salaries of regular employees.
Oh, that is heartburning. That is heartburning. That legal remedy, I can't give you a balm for that. The other part, legal, I have given you a balm. And we'll also provide that in the event the petitioner or the private respondents have become overaged in the meantime, they'll give you that relaxation. You're still working?
Yes.
You're working as
That's
driver.
I am a contingent staff being used as a driver.
What is your call? You have the qualification for this post?
Yes, yes, I have. Certificates are attest.
Class 8?
10.
You are class 10?
Yes.
Okay.
No.
Will post it. Dispose of it. नाम खाली दे विकास. Seven was adjourned. 7 was adjourned. Probate.
Wait, please, your lordship.
Hmm.
Lordship, in this, there's an IA file.
Hmm.
In the IA, we have to file an objection, my lord.
Hmm.
But we are collecting some documents, my lord. Here, what we
That
found. my lord-
other tribe people
Yes,
have filed.
yes, my lord. My lord, they are not even scheduled tribes. That is
Great.
in 2019 onwards.
Bring it on
Yes,
record.
my lord. Yes, my lord.
Let him bring it on record.
Yes, my lord.
Mr.
And,
P.D. Nayak, Learned Counsel appearing for the, this is 146, I suppose.
146, my lord.
No, IA 146, huh? ISC 146 AP 2024. Mr. P.D. Nayak, Learned Counsel appearing for the opposite party, oblique, the writ petitioner, submits that he be granted further 2 weeks' time, 3 weeks' time to file his objections in the matter. Full stop. Prayer accepted. The opposite party is granted further 3 weeks' time as a last chance for filing his objection in the matter. Registry to list this matter immediately on completion of 3 weeks from today.
My lord. My lord. Immediately.
बाकी नहीं चाहिए इसमें रिट पिटीशन रिट अपील में वो लिस्ट अगेन आफ्टर 3 weeks करके.
Deep
Yes.
My lord, I have talked to my client, madam.
Ah.
Talked to my client,
Oh.
and I have gone through equally, madam.
Ah.
Lot of anomalies in this in his notification, madam.
Yes, show me.
Because they are talking about a promotion of headmaster of secondary school. But this post doesn't belong to secondary education.
That was it's actually challenge.
That has to be challenged because
Yes.
there is no deputy director other than this. This is the only deputy director
Yes.
you have.
They are, madam, by force, they are illegally, arbitrarily, they are.
Ah, that is why I said you give me a scope to
My lord,
consider that rule,
my lord,
then you see.
my lord,
But you give me that scope.
my lord.
Withdraw this file.
Man, had it been within our knowledge, you would have challenged this.
You should and give him a complete set.
My
Mr.
Already given.
Mr. T. Tang, Learned Counsel appearing for the Education Department has placed on record the Deputy Director of School Education, Principal, Higher Secondary Schools Recruitment Rules 2010, which according to him governs the recruitment to the post of Deputy Director of School Education. Mr. Tamung has also placed on record a notification dated 28/11/2024 by which the provisions of the Assam or the Arunachal Pradesh Education Rules 2010, more particularly the Rule 55 bracketed 5 and 6 came to be amended by way of the Arunachal Pradesh Education bracketed Amendment Rules 2014 and the manner of recruitment to the post of Deputy Director of School Education, Principal, Government Higher Secondary School was now mandated to be so made by promotion, so made against 90% of the post by promotion from the cadre of Headmaster of the Vice Principal and 10% by promotion from the cadre of District Adult Education Officer.
Kindly, my lord, record at 10% and 90% post of headmaster and so on of secondary school.
Vice Principal, Headmaster will not be of a secondary school, it will be of secondary schools. Secondary schools and so. Full stop. In view of the above position and the rules holding the field having not mandated the post of headmaster headmaster of a elementary school, primary school, and of the post of BEO of the education service as a feeder, has not mandated post of so and so and so and so as a feeder post for the post of, for promotion to the post of Deputy Director of School Education. Mr. Purkhas fairly submits that he would now be required to challenge the provisions of the rules as holding the field today, and accordingly prays that he be permitted to withdraw the present writ petition with liberty to assail the rules holding the field.
And
Also-
and raising all other question,
Um,
all other question.
Coming. The above prayer is not disputed, is not objected to by Mr. T. Tamu, Learned Counsel for the respondents. Full stop. In view of the above position, this court permits the petitioner to withdraw the present writ petition to file an appropriate application assailing to initiate appropriate proceeding for assailing the rules holding the field with regard to recruitment to the post of Deputy Director of School Education, and it is also provided that the contention so raised in the present petition not having been considered on merits by this court, same will be open to the petitioner to be reiterated in such proceeding if so advised. Anything more?
Fine. Okay.
Deeply obliged.
Disposed of. Writ petition stands on withdrawal, disposed of, dismissal.
Have a good day, man.
Same to you. Next time, I'm here for a week, you can again come back. Yes.
My lord,
Huh.
this item number 9012, my lord, 9 and 8. We are not,
even filed an affidavit.
we are not going to file affidavit because the item number 10 we have filed, that will suffice. That will
Item
cover.
number 10, but
Yes.
yeah, when did you file?
Copy, sir. Have you received the copy?
Last date.
When did you file?
File करें.
Item number
4
10.
11.
10.
Oh, that, where is the file? ये नहीं है ना.
Okay, it's here.
My lord.
It's
So, my lord,
that will cover, that will do.
that will cover now, my lord. So, for item number 11 is concerned,
Hmm.
my lord, within a week, we are going to file the affidavit, my lord.
Okay,
And affidavit which you file in item number 10,
will cover 8 and 9.
8 and 9, if my
9 and 10.
9 and 12.
9 and 12.
Yes.
Okay.
If my brothers ma wish to file a reply to a rejoinder to that, he can file that, my lord.
Okay. Heard Mr. P.D. Nayak, Learned Counsel for the petitioner, and also Mr. Nawab, additional professional appearing for the state respondents. Mr. Nawab, Mr. Kamru appears for respondent number for the land
Land management.
management department.
Correct.
Director of land management.
Yes.
It's called director or the department?
Department of Land Management.
Department of Land Management. You have filed your affidavit.
Yes. Dano case, my lord.
Item number 10.
My lord.
I don't know. Also, it is submitted by the Learned Counsel representing the respondents that an affidavit has been filed by them in item number 10, and the same would cover the contention. So issues so arising in item number 10 have filed an affidavit in WPC number 193/2022, and the same would cover the issues so arising in WPC number 294/2024 and WPC number 455/2024. Right? Huh? Also, Mr. P.D. Nayak submits that he would file a rejoinder thereto within 2 weeks from today. Also, at this stage, Mr. Nawab submits that he would be filing an affidavit on behalf of the state respondents in WPC number
455. So I'm sorry, my lord.
174/2024 within
Yes.
2 weeks from today. Also, accordingly, registry to list these matters after 4 weeks. Also, in the meantime, the parties are at liberty to exchange their pleadings.
Item number 12, my lord, 445, my lord.
I may be served with a copy of affidavit of opposition.
They have not filed, that copy.
Not yet, we have
No, 12 we have filed.
12.
12 we are relying on 10.
Yes, my lord, we can serve. my lord.
The copy of the affidavit filed in in WPC number 193/2022, copy of the same may be provided to the learned counsels representing the petitioners in WPC number 294/2024 and WPC 455/2024. ऊपर में लिखिएगा hurt Mr. PD Nair plus Mr. L. Preming. Right?
Right, my lord. Obliged, deeply obliged.
If it is not intervened, probate, it's fine.
Since my brother is coming from Guwahati, my lord.
Oh, he is not from Guwahati. He is here only. He is in two places, Aizawl and Itanagar.
Itanagar,
So
Malam.
don't say Guwahati.
Malam, we
You
are-
don't find him in
We
Guwahati.
are thinking of issuing a PRC, my lord.
You give him. When? Yes, Mr. Come up. When? Give it a date 4 weeks afterwards.
4 weeks. My lord, any that February 1st, Monday to.
You give a date when it's convenient. 14 February.
Very well.
As prayed for by the learned counsel for the parties, raised it to list this matters again on 14 February. Except मार दीजिएगा 9, 10, 11, 12.
My lord.
Okay. Item number 21.
Yes, my lord.
21. Same thing. You have got the series.
Yes.
What is it?
Your Lordship, though his statement has already been taken, Your Lordship, it seems that he has admitted to have duped some other people, but then names of the other peoples are not revealed.
But he is in judicial custody.
Yes, therefore but then like,
But the only thing is, how do you ensure his presence here? He's not from Arunachal.
yes, only the condition can be put up is the local surety.
Local surety.
However, the problem here is, Your Lordship, on many occasions, if that that particular conditions are being given, Your Lordship, the apex court's ruling is also there that only on that condition, Your Lordship, on the next date, if there is no local surety, they normally comes and get it amended, Your Lordship, the orders.
That cannot be done. The Supreme Court has permitted that.
Yes, there is a authority where it says that only the condition that local surety, if the person does not have any local surety, Your Lordship, that strict condition should not be
Because
put up.
the apprehension here is, because this is a big network.
Yes.
And if not in Arunachal, they might have their roots next in Kohima or
Yes.
in Assam.
Yes.
420, according to me, is clearly attractive.
Yes.
Because the advertisement was issued by you. You motivated the man to part with his money. What more is required?
Now, he himself admitted to the fact that after he has used all the money, he avoided the calls and all those.
Ah. So, Mr. Hussain, what do you say?
My lord, any condition may be imposed.
But don't come back and modify for modification of that. Then we'll put some other very strict conditions.
Yes, my lord.
Because otherwise we cannot ensure your presence here.
Yes.
And what do you say about the criminal petition?
Yes.
You withdraw this criminal petition. There is nothing here. This has to be tried. Clear material against you in the FIR.
FIR only, my lord, he suggests him to invest.
No.
Yes.
You took the money.
I have not taken, my lord.
Who? From the account number, namely Amir Hussain Ali.
Yes.
So and so, so and so, so and so. I have paid totally amounting so and so, so and so through online transaction to his bearing. This is not your account.
This is not my account, my lord.
No, Your
So who said?
Lordship.
Huh?
The CD reveals all the payment was made in his account. Your Lordship.
Then it is here.
Yes, my lord.
So 420 is clearly. Now, if I come in, I'll have to
No, no.
observe that.
My lord, he deposited money in my account to convert the money to dollar, and I return back all the dollars to him.
No, that is not here. Where did you convert that dollar? Where did you make that conversion? Where is that material that you convert? You can't convert dollar going to US. You have done it in some foreign exchange business foreign exchange, maybe authority
Yes.
or foreign exchange dealer. Where is that material? That you converted that?
My lord,
Where is that material to show that you converted the dollars into dollars and you received the dollars from his money, paid it to you? Where is that material?
my lord, if you permit, then I will submit an additional affidavit.
Okay, you submit an additional. Let him be here for some time.
Yes, my lord.
Item bail application and bail application. Mr.
A.
Ms.
Rahman.
T. Jini, learned additional public prosecutor has praised the bail, has praised the CD received by her in the matter, and on perusal of the same, it is seen that there is incriminating material brought on record against the accused petitioner herein. So accordingly, the learned counsel for the petitioner submits that he be permitted to file an additional affidavit in the matter. So prayer accepted, additional affidavit be filed on or before 3/1/2025, registered to list this matter again on 8/1/2025. Item number 21. Heard Mr. M.K. Hussain, learned counsel for the petitioner, and also Ms. T. Jini, learned Mr. T. Tado, learned counsel appearing for the learned additional public prosecutor appearing for the state respondents. Full stop. In view of the materials so brought, full stop, Mr. Tado has placed before this court the case diary, and in view of the disclosure made therefrom about the involvement, about existence of incriminating materials against the petitioner herein, the learned counsel for the petitioner submits that he be granted an opportunity to file an additional affidavit in the matter. Also, prayer accepted, additional affidavit, if any, be filed on or before 3/1/2025, registered to list this matter again on 8/1/2025.
Your Lordship, in both the matters, updated CD may be called.
The learned additional the additional public prosecutor appearing in the matter shall on the next day. CD is written. An updated CD be placed on the be produced on the next date of listing. Dono case, dono में ही लिख दीजिए. Yes, ma'am.
Yes, ma'am.
Statement has been recorded.
CD has not received yet, Lordship.
Okay. Miss,
Short date may be
a
given.
prayer has been made by on behalf of the petitioner, the counsel for the petitioner for an adjournment in the matter. Full stop. Ms. L. Hagen, learned counsel for the additional public prosecutor submits that the case diary has also not been released or not been received. Full stop. In view of the above, registry to list this matters again on. We'll have it
19 Lordship, or 18 or 19?
18.
Not 18. Lordship.
On 18.
Lordship 19.
18.
18 Lordship.
18.
It's nearby only,
Oh,
Lordship.
19. No problem. 19/12/2025. Interim order passed earlier to continue till the next date of listing. On the next date, the case diary be placed on record by the learned additional public prosecutor.
License.
नाम ले लीजिएगा. Item.
Obliged.
So the matter has been listed in terms of the directions passed by the Honorable Supreme Court, wide order dated 21/11/2024 in Civil Appeal number 1288/2024. Full stop. In the above view of the matter, the registry is directed to list this matter for this, the above, registry is directed to list the above revision petitions. दोनों एक साथ मार्क करिएगा. 20, 15 and 16, for admission. When?
After 3 weeks.
No, expeditious. January.
Your Lordship, we will have to take instruction from our clients.
You take whatever you want to do on 8/1/2025. 8/1.
DP of line.
For admissions लिख दीजिएगा. Still the, yes,
In this matter, my lord, I have been informed that Mr. D. Gogoi, standing counsel forest, he would be appearing. Informed him yesterday.
for whom?
For the forest department of Assam.
That means for respondents number
Respondent,
8,
Eight.
for 5 and 8,
5 also, my lord,
5 and 8,
my lord.
but the others,
Others, I have been informed, my lord, that they are in talks with,
we'll adjourn it,
my lord.
we'll adjourn. This matter would require a consideration, not something to be rushed into. Seen the office note dated 13/12/2024, which reveals that service report upon the respondent number 4 to 8 is yet to be received. In view of the above, await service report upon the respondent number 4 to 8 for further 4 weeks.
Could it also be taken up on the same day, my lord?
Registry, as agreed to by the learned counsel for the parties, registry to list this matter on
14.
14/1/2025.
14/2, my lord.
14/2/2025. Oh, you're not coming here for a month now. That's bad.
My lord, there's an interim order.
Interim orders, if any, shall stand extended till the next date of this.
Item number 8 also, could it be taken up on 14th as well, my lord?
Item number 8.
8.
Oh, that matter.
That matter.
Item number 8 भी madam है तो 14 कर दीजिए, हाँ? 14 कर.
Deeply.
May please, my lord. My lord, this IA is filed for the suspension of sentence, pending appeal and release the convict on bail, yeah, my lord.
Everything is ready. We'll hear the appeal, madam.
My lord, convict is,
We'll provide for, we'll direct that he should be provided with the best of the treatment that can be provided. And in the meantime, we are taking it up. Very, it's a prosecution has been able to establish again the case against you.
yes, regarding also in the division
And
bench
your
also.
plea that there was another man, it came up only in the trial. Before that, is there any reference to Keto Gingo?
Yes, lordship, this is the order of the division where IA is in disposed, lordship. There also there's a medical issue has come up, lordship. So it is,
That's what,
yes, dispose of duly that is petitioner, this one, but accused person has to be given medical treatment by the duly authority, lordship.
you are giving him?
Lordship, if direction is passed, then it will be provided by this.
Okay.
So that IA may be disposed of, simply made a direction to medical facility may be.
We'll. Madam, if you want to hear it, I'm ready today.
My lord, for final argument, it may be, I may be give next date.
Okay. IA, Criminal 90 AP 2024. The present application has been instituted, praying for suspending the sentence so passed by the learned trial court, while judgment dated 16/3/2021, and for grant of bail to the petitioner for his treatment. Full stop. It is submitted by the learned edition, full stop. On perusal of the materials brought on record, this court is of the considered view that the petitioner can be provided the treatment even while he is in custody and for the set purpose.
Lordship, otherwise, lordship, because this is the IA lordship, they have both the notice regarding the health issue, lordship, but we have not received any.
I'm providing for that today. Can be provided in the jail. It's while under detention. Full stop. Miss so-and-so, learned additional public prosecutor L. Hage, learned additional public prosecutor submits that the ailment suffered by the petitioner has not been brought to the notice of the jail authorities, and accordingly, the same could not be taken care of by the jail authorities. Full stop. In view of the above position, while not entertaining the present interlocutory application, it is provided that the jail authorities, the superintendent of jail, which is the jail?
District Jail Julie.
Superintendent of jail, district,
Jail.
the jail district jail, Julie,
Julie.
shall provide to the petitioner the due medical attention as required by him, and for the said purpose shall have the medical condition of the petitioner assessed either by the jail doctor and or by a specialist,
Specialist, yes.
by a specialist for the ailment so suffered by him. And thereafter ensure that the petitioner is provided the treatment so required by him for his ailments. Full stop. With the above observation, the present IA stands closed. Full stop. Criminal appeal. Full stop. The appeal is ready. What does it mean? Madam, there is one more point. Criminal appeal. The criminal appeal, appeal is ready as regards service of notice upon the respondents. So further, the paper book has also been prepared. So in the above view of the matter, raised it to list this appeal for hearing on both of you agree?
23rd January.
On
23rd.
23rd
January.
3/1/2025.
Obliged.
And you also communicate to the jail authority about this.
This is the same probate case. Last occasion, we have already demonstrated. None of the witnesses have been there. That's
The basic requirement according to you is that the mental condition and the health condition of the testator has to be, of the executant of the will has to be proved. Secondly, there has to be at least 2 executing witnesses, and they must have seen each other attesting the will as well as the signing on it by the witness. Now, when there are names, there are names, but when the will was being probated by him, the private respondents or the DW 1, 2, 3, and 4, whom you produced, they refrained from making any statement in the matter. They disputed their signatures, but the learned trial court did not forward it to the forensic for examination, who by contending that observation I have not understood, by contending that this was only an opinion, it would have been an opinion. But he has thereafter gone to dislodge disbelieve the statements made by DW 1, 2, 3, and 4. Now, there is one witness, that is the registering authority.
He also has not seen.
Now, whether he, in the scheme of the execution of a will, is of anything, because he also does not have not seen the lady, your mother, executing the will. He has not seen the attesting witnesses putting their signature therein. The will was taken to him by the
respondent.
This is the case?
Yes, madam. None of them has seen, neither the respondent himself has seen his mother even affected.
He has seen his
Not
wife
his
was
wife.
there. His
Wife
wife
was-
was a witness. She said,
I'm not
I
there.
went there, I saw, but she says D2, D3 and D4 were there.
Yeah,
But she
she was-
gave them tea and thereafter she has not seen. She is
Yes.
very categorical.
She has also not seen any of them.
Yes. Yes. You can start now.
Yes, you. Now, in such situation, that's what I already said. All this section 71 of Evidence Act,
You have not placed any judgment, na?
I have placed.
Which is the one you have placed? NV Balasubramaniam.
No, you are Ramesh. Just a minute.
Ramesh Verma. Mr. Panning, you have relied upon Sushila Devi?
Yes, MB Ramesh
Ah,
and one was,
this is by you, NV Ramesh?
yes,
Ramesh Verma, dead.
Ramesh were dead. Yes, MB Ramesh came, then Saroja and others versus,
Saroja and others versus,
and then Sushila Devi. This
then three you have delayed
Yes.
on. Sushila Devi. Okay. Okay, please continue. And Mr. Ratan, you have relied on
Jagdish Chand Sharma
Jagdish Chandra Sharma,
and then Ramesh Verma,
Ramesh Verma, Ramesh Verma dead.
and then this is Yumnam Ongbi Tampa.
That 2009 4 SSC.
Yes, madam.
Yes.
Yes, Mr. Chandra.
First of all, my lord, I've page 12, where while filing the petition, the DW
He was a verifying witness.
verifying witness,
Yes.
he has not
He is DW.
DW 3, Obang Mengu. Yes, he has, your lordship, nowhere in the in chief, he has not clarified about this. He has not denied, or he has not said that I have falsely signed in the verification. Nowhere he have explained about this. Then, my lord,
Now, this was, to your knowledge, did you cross him on this? That is DW3.
yes,
Hmm?
DW 3,
Page 44.
yes, 44, cross. Yes.
Nothing is here. There is no material.
Yes,
No cross with regard to that fact that
Yes.
he is. Where is his affidavit? Affidavit of the evidence on affidavit
of DW,
for
Three. That is at page 40.
14.
14, no, 40.
40.
He has not mentioned anything about that.
So he is your brother-in-law.
He is the brother-in-law.
Brother-in-law, your brother-in-law.
Both of us brother-in-law.
Okay. He says he's the brother-in-law of Obidai.
Yeah, Obidai is the brother of Ojingdai, who is the appellant.
I know that.
Yes.
Brother-in-law married your sister or you married his sister?
I married his sister.
Then how can he be his brother-in-law? He's your
The
brother-in-law.
as per clan, that is the way.
Be that as it may, we are under Succession Act now.
Yes.
So he's an interested one. He was an interested one with you.
Yes.
But still he made this statement.
Yes.
Okay.
Then, Lord, I'll in the categorically in my in chief, the PW 1.
So this statement that serial number 4 was not disclosed by you in cross. Okay, fine.
Yes.
Then next.
Then, my lord, I'll come to the PW 1.
PW 1. Where is that?
Page 29.
29.
So he has categorically stated that I'll come to page, everything is relevant, but I'll come to page 30. That since the incident, para 30 page para 2, since second para, since the incident, our mother on daily basis asked me to take her to the office of Deputy Commissioner so that she can inform the Deputy Commissioner and divide the properties between both the brothers. Being bored by her, with her insistence, I one day called up Advocate Gita Panging at my residence and introduced our mother, and Advocate Gita Panging suggested our mother to make one will, testament, and there is no need to go to Deputy Commissioner for making will. As such, our mother requested her to prepare the will. Further, Gita asked her to arrange some witness. Also, and on request of my mother, I called up the Okok Iring, Tajir
Okok Iring is?
DW. Okok Iring is DW 1. The DW2 is Tajir Tapak. Then DW3 is the Obang Mengo. All agreed to stay.
And you were DW? Appellant was DW?
Appellant nowhere here.
He did not. He did not.
Yes.
Yes, okay, fine. Go ahead.
So all agreed to stand to witness before Gita Panging and our mother, and thereby Gita noted their names and went back and asked me to get non-judicial stamp paper, which I handed over to Advocate Gita Panging. I also remember on 30/10/2006, I was called up by Gita Panging to take the will draft from her residence, which I did, and inform our mother about the will draft. All such information, she directed me to call all witness on her very next day. On 31/10/2006, in the morning hours, I realized that we were further needed one magistrate to countersign the will. Therefore, I personally made Sri Atin Padung, circle officer, at his office and informed the old age condition of our mother and requested him to come to my residence to witness the execution of will of my mother, which he agreed to come.
Why is this required? It's not a requisite.
Not required, but yes. That around 2:30 p.m., I called up all the witnesses in my residence as per mother's instruction and had tea while waiting the magistrate, but when magistrate did not turn up till 3:30. As such, I made a call to magistrate informing the waiting of the witnesses, where my magistrate suggested me through phone to take their signature before our mother. Accordingly, all witnesses went inside the house and asked our mother to inform magistrate that they all put their signatures before her, all put their signature on the will and left. But interestingly, all the witnesses were intercepted near my gate by the magistrate and informed the magistrate by those witnesses that they already put their signatures. On arrival of magistrate, he was first offered tea by my wife, and thereafter, after a little conversation, the magistrate went inside my house and inquired mother whether all witnesses put their signatures before you, which mother replied yes. But the magistrate, instead of putting his signature in the register itself, directed me to bring the will paper and take his signature and seal at his office and suggested me to register the same. Thereafter, I followed him to his office and took magistrate's signature and seal at the office, and thereby the magistrate told me the place of registration and got registered on the same day. I said that after shifting of our mother into my residence till her death, my elder brother never visited our house except funeral day. Our mother was suffering from all illness and paralysis for more than 5 years.
Mr. Bachchaji, just interrupting you
Yes.
for a minute. Now, this is the only statement with regard to attestation by the witnesses of the will. But where is the statement here that your mother had also signed the will before them?
Yes, that is not there. He has not seen it.
But he knows everything else.
Yes. I don't know that because there was trial lawyer was some.
I called up all witnesses in my residence, so and so, so and so, so and so. All witnesses went, asked our mother to inform the magistrate that they all put their signatures before her. All put their before her, put their signature on the will and left. Now, the mother signing it.
Yes.
Mother signing it is not here.
Yes. Yes, your lordship. Thereafter, this what this important paragraph is there while filing the probate
Just a minute.
application. While filing the probate application as per requirement, I requested Sri Obang Megu for verification, which he verified without any objection whatsoever. Further, I like to say that my elder brother is strongly objecting the probate of the will. In fact, more properties have been given to my elder brother as per will. That also
Will has divided the property between both of you.
Both. And most of the properties are gone to him only.
He is with that beads, local beads.
Beads. I also state that after filing a probate petition, all the witnesses in the will approached me in many occasions and requested me to withdraw my case, or else they will deny their signature in the court. As they said that they do not want to be harassed mentally by my brother Sri Ojingdai, and also they said that they do not want to be troublemaker between both the brothers. This is the situation.
Now, where is your cross? Page 35.
Page 35, yes. I'll read the last part also, where he prayed for forensic. I said all the witnesses have denied on being witnessed before the court only on behalf and duress of my elder brother and nothing else, and therefore during the pendency of the probate application, all the witnesses given me a letter denying of giving their signature in the will of our mother. Therefore, my request to this honorable court is to send their signatures for forensic examination and for comparison of the signature of Sri Okogiring, Sri Tagir Tapak and Sri Obang Megu for better verification. I am enclosing here with the letter in original of their letters as annexure A, B and C respectively, and same is exhibited as exhibit PW1, exhibit PW2, paper exhibit PW2 and paper exhibit PW3 respectively.
And the DWs also had reiterated this.
Yes.
I don't know why the learned court below did not accept this.
Yes.
That would have been an additional, but still the lacuna that remains is when the mother signed.
Yes.
Can we just disturb you? Can we have the evidence of the magistrate?
Yes.
He is a DW or a
DW.
Okay.
They all retract. They all have they didn't agree to come with their petition.
There can be another view also.
Yes.
Normal human conduct. Yes. That they did not do it, so they did not support you.
No, they returned a letter saying that to withdraw their
names.
So
Okay, where is that man, the magistrate?
Magistrate.
Page 45.
45.
Where is this?
This is
affidavit? Oath on in affidavit. Okay. He is DW 4.
4. This is the cross.
No, this is the affidavit, the 41,
45,
41, 41.
41. Yes, 41 is the affidavit. The last will of late Opedai, wife of late Lomidai, was brought in my office by Sri Obidai, son of late Lomidai, for execution, which I have executed on understanding. Late Opedai has not put her thumb impression on the so-called last will before me or my presence. The witness of the last will of late Opedai, namely so have not put their signature before me or in my presence, and they have never attended in my office as witness in the last so.
Now you
Yes.
see there are two.
Yes.
He has not stated that the lady, that the mother had executed or put her thumb impression before him,
Yes.
or that when he went, there is evidence that he had gone home.
Yes.
The will was already executed.
Executed.
He has not said
That's
that.
not true.
What is the cross?
In the cross, he says that I have been summoned as one of the witnesses in this probate case. Also, I know a will was executed by one Opedai, mother of Obidai before me.
This is the subsequent thing to
Yes.
that extent,
Yes.
not the attestation made
Yes, sir.
while executing the will.
Yes, sir.
This is the registration or the counter signature done,
Yes.
which admittedly was not taken by your mother, was taken by
Yes.
you yourself.
Yes, yes.
Okay.
The B exhibit shown to me today before this court is will executed by
Opedai before me.
Opedai before me. And P exhibit 1A, P exhibit 1B, and P 1C are my signatures thereon.
Why 3 signatures?
That is his signature.
No, why, where is that original?
Will is
the will here?
the will should be there.
Exhibit 1. Interesting. Have you gone through the original of the will?
Original I have not seen.
I think it's 3 pages, therefore.
3 pages.
Therefore,
1, 2, 3 pages.
Therefore, 3 signatures.
3 signatures. No. That is. It is something else. You have not seen it.
Yes.
Is the will copy on record?
Yes.
Where? Annexure?
Annexure 13, page 13.
Page 13. Okay. Mr. Bachari, clarify one thing. What is that act of signing called? Execution?
Yes.
Say I make a will. What am I said to do? I am executing a will.
Yes.
Am I right in saying so? If I make a will and I sign there,
Yes.
you both are my witnesses. How will it be said that I have executed a will? Right?
Yes.
Can it be anything else?
No.
Means the act of putting my signature in the will and the attesting witnesses putting their signature completes that act of execution. Now you come to page 50.
1-5.
1-5.
Yes.
This whole thing destroys your case. This is the end of the matter.
Yes.
Executed before me today, the 31st October, in presence. The whole will is thrown out of the window. Totally false statement. He himself says
Yes.
that you brought it. You see, solemnly affirmed and declared before me by Srimati Opedai at Pasigat. executed before me today, the 31st October 2006, in presence of witnesses. This whole statement is.
That's what your lordship. We are saying that these people are not.
No, this is when it was executed before you.
Yes.
No, I'm not on the evidence part.
Yes.
We noticed the evidence.
Yes.
The evidence is that this was taken before him in the office by you.
Yes.
Right?
Yes.
And there is no doubt, no dispute on that. You have also not disputed that. That you took the will to the office of the magistrate.
Yes.
Because your wife has also, I think, supported that. You have also said.
Yes.
Right?
Yes,
In your
yes.
state PW1 statement, you have said
it
that.
is there. It is there.
So now, if that be so, that you have taken the will and you have got it signed, countersigned by the magistrate,
Yes.
then what about this? What is he saying? Solemnly affirmed and declared me before me by so and so at Pasigar, executed before me today, the 31st October, in presence of witnesses. Now, your own statement says the witnesses, magistrate and your mother were never together.
Yes. No, that is there. He brought this will to the office. That is admitted.
Admitted.
Yes.
So now the will was never executed. This certificate
Yes.
that he is saying. If this was not, he was just countersigning, we would have understood.
Yes.
But what is he doing? He is saying that this will was executed before me and in presence of witnesses. That's a wrong statement on the face of it. And as of 31st October 2006, he was, I will say, Mr. Pani had won over him subsequently. But on 31st October 2006, he was not won over. So how can you support this now? The learned trial court, unfortunately, has not examined this issue on this line.
Yes.
So this document itself is wrong. What do you have to say on that?
So usually this the magistrate they simply they have already have stated on understanding have signed it.
But
Yes.
but the statement here is different. He says, I've not seen it earlier. He says that declared before me by so and so.
Yes. So this is the witness of the now DW.
No. Page 15.
Yes.
Forget the witness.
Yes.
Now, he is saying that this deed was executed by 2 witnesses or 3 witnesses, was executed by your mother in presence of 3 witnesses and he,
Yes.
which is wrong. Whatever evidence you bring on record now
Yes.
cannot cure this. Because this will was never executed before. That's why I asked you. What is that act of signing and attachment made by 2 witnesses called? It is execution of a will.
Yes.
So the will, as per this will that is there, was executed in presence of the magistrate in his office. And your mother, and by your mother, and 2 witnesses, which is on the face of it. What do you have to say on this? Say this is a fact.
Yes.
This is a fact in issue.
Yes.
If this projects a picture different and which has the effect of damaging the whole will, whether any subsequent oral evidence or the other evidence cure this defect. That is my query to you.
Now, your lordship, this part they have not said anything either in the in chief or in the.
But this is something staring before me.
Yes.
Because this is a will.
Yes.
And the will has to pass through certain conditions.
Yes.
To attain a state of being probated.
Yes.
Now the very will is not permissible to be probated.
So that's why from the very beginning we are saying all the witnesses they
okay, fine. Anything more?
Yes. Then
he could have just given a counter signature, that's all.
Yes,
Because this part was not even required.
yes.
This solemnly affirmed and declared before me by so and so is not required. Because a registration of a will is also not a
Not required.
mandate. Then
Not required. However, your lordship, if we see those witnesses, these the attesting witnesses, they in the midway they have
we'll examine that.
they turn back
We'll examine that.
and
Anything more, Mr.
yes, I will that's what I am saying in such situation, your lordship.
How do this court
This-
proceed? Yes.
Enabling section is 71 to bail out the such situation.
Evidence Act. Evidence Act, section 71.
71.
Okay. Okay.
My humble submission will be that, your lordship, that execution before the magistrate, suppose if it is also not executed. Not
That
registered-
still would be a valid will.
suppose it's not, I mean, for a moment, if I say it's not registered at all, then also the will was executed by the mother and these three attesting witnesses are there, but they have turned
Turned out.
up. They
Ah.
were being owned up by the appellant. So they didn't came in my support to give the evidence also.
Okay,
They
okay,
came in the support of
okay.
the.
Okay. Now, you say by referring to section 71, that if this can be a situation, that is why it was envisaged here.
Yes.
Then it can be proved by other evidence.
Other evidence.
Now, what would be the other evidence other than FSL report?
Yes,
That the court never went through.
yes,
The court's view was that that is opinion only.
yes.
There is no other evidence on record
Yes.
to establish. If there is
Then-
something
then-
else, kindly show me.
Yes, in that case, honorable court may send it back for official. My humble prayer will be there. For official to ascertain their signatures.
That we have, you could have submitted an application there. You could have submitted an application requiring, because that power is there
Yes.
of the court.
That trial part, your lordship, I was not.
No, that today we can't.
Yes.
We can't act to his prejudice.
So, your lordship, it's already clearly in the evidence. We have prayed for the.
It has been.
Yes.
What is the procedure before the trial court under the Code of Civil Procedure for examining or sending these documents? There is an application required to be filed under which provision?
I think it is evidence like 145 is there for.
145.
Yes.
No, that is the power of the court. For you to make
Not 155.
No.
Not 155. 45. 45. Opinion of experts.
Identity of our opinion, so and so, so and so, so and so, so and so, so and so are relevant facts. But you have not taken recourse to this. Okay, fine.
Moreover, lordship, I will take that IA also, where the one of the attesting witness have come up with the truth. The letter is
No, that is after this proceedings.
Yes.
The learned trial
So
court.
you're from the very beginning.
The learned trial court did not have an occasion to consider that.
Yes.
You have not filed any application for review.
Your lordship, I'll say why that situation didn't arise at the trial court. This person at the end of the trial, he came to me verbally saying that we were not made to speak the truth before the court. Therefore, I'm very feeling.
No, under such situation, what is the way out?
Then, in the meantime, judgment was passed.
No, got it. If the judgment is passed, but this is a situation that has
Yes.
arisen because a witness has been forced or
Yes.
coerced
Yes.
or deceived
Yes.
to submit in a particular manner.
Yes.
What would be the course open to you? Not an appeal, not in before the appellate court.
Yes.
You will have to file a review.
Already your judgment was passed. Therefore,
that is why the review power is there.
Yes. Therefore, they were not so much aware. I don't know that, but therefore, after passing
Ignorance of law cannot be a ground for appeal.
That's there. Yeah. But thereafter, your lordship.
Any other point, Mr. Butcher? What is the judgments you are relying upon? Any other point? If you want to complete, you can complete. Any other point you want to touch?
Is the judgment is that this.
So submissions, basically only this. Your submissions?
Yes. Basically, my submissions that yes, that regarding my submission is maybe in a very nutshell, it will be that I pray that it is already executed as per section 63 and 68 of Evidence Act, and then the attesting witness they retracted and tried to help the appellant in the trial, and then but however the honorable court could uncover, the trial court could uncover the conduct of the attesting witness, and the attesting witness were owned up by the appellants, although they supported the appellant, yet they failed to convince their signature on the will were not actually signed by them, and that any fraud or forgery was committed by the respondent. They also alleged in their written statement that I committed forge. I have forged their signatures. So my humble submission is that it will be against the rule of law if the fate of the genuine legatee is placed at the mercy of the attesting witnesses. Keeping this type of situation only, I am referring to section 71 of the Evidence Act for rescue of a genuine legatee when the attesting witness retracts from the truth. So section 71 says that if attesting witness denies or does not recollect the execution of the document, its execution may be proved by other evidence. The Honorable Court law below has applied this provision rightly, and he has appreciated the order.
But he has appreciated that in air. There was no other evidence available. Other than the
DW4 in his cross, he is relying on the DW4's cross.
Oh.
The trial court.
Okay, DW4.
Yes.
Let us see. That is what led me to see the DW. Page 41 is the original.
Yes.
Cross is page 44.
45.
So and so, will seems to be mine, but I don't remember. No, DW4, sorry, 45.
Yeah.
I was summoned to be as well. Also, I know the will was executed by one so and so before me. The so and so showed me is the will executed by before me.
Yeah.
Are my signatures. I have not seen this again is damaging to you.
Yes.
Because he says that will was executed before me. He stands
Yes.
by the disclosures made in the will. He does not say what you have said.
Yes.
But when we factor in your statement, this is totally wrong.
Yes. Lastly,
Will was brought to me by so and sorry, he says, and apprised me that witnesses shown in the will have already put their signatures before it was brought to me. But where is that satisfaction wrong? That the mother has also. Because nobody has said that.
Yes.
Because he cannot know. DW4 cannot have the knowledge when the mother put the signature. That could have been said by you from putting it in the mouth of the DW2, 3 and 4 that they said, when you have said that, okay, the statement, the will was, we had signed. If you had added a line there, that signed and my mother has also signed, that would have been some relevant. But today that admittedly is not there. See, the only thing I am finding in difficulty is There is no statement on record other than PW4, DW4 that your mother has signed.
Yes. That's the situation, Your Lordship. Therefore, in chief of the PW1, he has categorically mentioned all those situations.
I know, but he has omitted one thing that the mother had also signed. The mother has to sign first.
Yes, yes.
Then the witnesses.
Yes.
The witnesses only said we signed. You said the witnesses signed. But whether the mother at the same point had signed or not, that is why a doubt arises of forgery. Because a thumb impression was taken. Mother passed away 2 years afterwards. I think the proceedings were thereafter.
6 years
After that.
After 6
And
years.
when was the proceeding instituted?
2012.
After the
after the date.
That.
After the date.
Because he says he did not know about that. Thereafter, after the death, he came to know. So that thumb impression, whether it's of your mother or not, no evidence on record.
Yes, that is what that's what these witnesses they already turned retracted.
No,
They
even in your statement, where is that statement
he
of
has-
yours
Yeah,
that
yeah,
your mother
yeah.
had also, that even if it's a hearsay one from the, but if he could have said that from the witnesses I have heard, my mother has put her thumb impression and thereafter they had signed. Finished. Okay. Anything, what are the decisions you want to rely upon?
Lordship, in the categorical statement of the PW1 and 2 has not been rewarded by the.
There is nothing.
Yes.
There is
But
nothing.
they have
I
said.
told
They
you,
have said.
they have only said that the witnesses told they have signed.
Yes.
2, the magistrate was not there.
Yes.
PW2 knows nothing. She only knows about the presence of the 3 DWs before in the mother's room. She does not even say that they had signed.
Yes.
Or your mother has signed because she does not know about it. PW1, that is you, said, I had heard. I did everything, then heard that they were leaving and they said that they had put their signatures. That's all.
Yes.
Whether your mother's signature was also put, that you have not discussed.
The date, Your Lordship, already the DW3, Obang Mengu has in the verification also, he have stated that.
But he retracted subsequently. And in your cross, you could not demolish him.
This will be, Your Lordship, it will be amounting to admission only.
Because
he
was not comforted by you during cross with that material.
He was supposed to clarify it.
Why? Why did you not comfort? It was your thing. You should have comforted him. There is not even a suggestion to that effect. Have you seen that?
Yes, very clearly, Your Lordship, categorically stated in the verification.
I know
have
that.
seen.
I know that. But there is not even a suggestion made to him during cross that you have retracted, but you had signed. See.
Yes, that is the trial court advocate.
And let us go back to that. Let us go back to the verification once more. Where is that? Page 12.
Yes.
Now, what is the requirement for execution of a will? The testator has to sign.
Yes.
And 2 attesting witnesses have to be there.
Yeah.
And they have to see each other and the testator signing. It is not here.
Yes.
That line is not here. I saw the testator affix the signature to the will annexed to the so-and-so. One of the witness to the testator, testament of the testator mentioned in the above petition do hereby declare that I was present and saw. Where is that evidence or where is that statement that the other 2 witnesses have also signed in his presence?
Yes.
Okay, what is the decisions you? Which is the first one you want me to take?
It's Lordship, I'll rely on MB Ramesh.
MB Ramesh, para 25, 26.
1821, 25,
18?
1821,
1821,
18 to 21.
18 to 21.
Then 25 and 26. They have submitted the Lordship Saroja and others versus.
Just a moment. Now you come to page para 20 of this Ramesh. PW2 has stated, have you got it? Placitum F.
Yes, yes.
Page 500, Placitum F. Just near Placitum F. Down below, para 20. 1, 2, 3, 4, 5, 6 lines of para 20. Para 20.
Yes.
PW2 has stated that he has signed the will in presence of Nagamani and she had also signed the will in his presence. It is, however, contended that his evidence is silent on the issue as to whether so-and-so executed the will in presence of M. Malage Urs and whether Malage Urs also signed as attesting witness in presence of so-and-so. Now you see, section 63C of this very much lays down that the requirement of a valid and enforceable will, that it shall be attested by 2 or more witnesses, each of whom had seen the testator sign or affix his mark to the will, and each of the witnesses has signed the will in presence of the testator. So-and-so will has to be proved like any other document, except that evidence tendered in proof of a will should additionally satisfy the requirement of section 63 of the Succession Act, apart from so-and-so. Now, if you come to para 25 or 26, '25. '25, this is what I was trying to see in your clearly absent. Because there was a statement, at least 2 witnesses, the minimum is 2, both saw each other and the testator signed. That's why the Supreme Court said the other evidence we can proceed. But here, totally absent. Next judgment. Sushila.
Yes.
Para?
Para 5 and 11.
Here it was given, I think, to somebody else, not to the blood children.
Yes.
This will not help you because there were a lot many attesting witnesses and they had reiterated. And one even, if I remember, I've just gone through it. A few years back before execution, 1935 or something, he had said that he will not give anything to his son, but will give it to so-and-so. So that is why the Supreme Court has said, say, para 11. Discuss with him in breaking will. He told him that he is desirous of bequeathing all his property to Govindamani, as he is considered him as an adopted son. should bequeath some property to his second daughter, told that he had given her some money and he proposed to give her some more. But he would be not giving so and so, which is clearly acceptable, goes to prove that the bequest made by the so and so cannot be considered as unnatural. Because the plea taken was normally a man will not give the his wealth outside the family. So this, unfortunately, I'll go through it again, don't worry. Then what about Bala Subramanian? That is also referred by you?
Yes.
Madras High Court?
Yes.
Para?
15, 20 to 26.
15, 20 to 26, right?
Yes.
Now you come here. Para 15. "15 lines from bottom. It starts with the word in other words. Right?
Yes.
There is conflicting evidence on so and so between so and so, but there is one neutral evidence, namely evidence of DW4. He is the joint sub-registrar and he has in his evidence deposed that both the attesting witnesses have identified Muttusamy Pillai and signed on the backside of the first page of the will as identifying witnesses when the will was presented for registration. So and so has admitted that the will was executed by him and then he has affixed his thumb impression when the will was presented to him for registration of the will. Here he has put a specific question whether it was a will of so and so. So and so he said that the will was read over and only gave affirmative. So here there was that your section 71 to resort to 71, there were material available, which unfortunately is not there in your list. Anything more? This much only.
That's all.
Give me a small note.
Yes.
Whatever you have to say, give me a small note. Not a big one.
Yes.
Your issues, I'll deal with. Mr. Radhan, you also give me. Can you give it to me in a day or two?
Yes, Master.
You can mail it down. You did not come down.
Yes.
You're coming from outside.
Yes.
You can mail it down.
Yes.
Thank you.
Public.
Wallahi.
I learned a lot. But you will get it on reopening only. I'll put it here, get it on reopening. If possible, if I can do it here, if you can give me a note by day after, Tuesday, Wednesday, if you can give me, I'll try. Okay. Third day, learned counsel for the parties at length. Hearing concluded, judgment reserved. You can just give me a written note.
Wallahi.
See. Yes. Who is that? None appears for the party on second call. Who? Relax, relax.
Yeah, only small prayer, Lordship. Item number 25 to 27, respondent counsel has mistakenly informed the date 10th of January. Kindly the date may be granted for 10th of February, Lordship, instead. And for item number 5 also, Lordship.
Should be 10th of February.
And item number 5 also, Your Lordship.
Item number 5,
And
25 to
27, Lord.
27. 10 to.
Deeply obliged, Your Lordship.
दो बजे हाँ 2 बजे इसका भी और नहीं है खत्म बोला टाइम है
My lord, whenever I could collect, my lord, I have placed a list of them, my lord.
Who is appearing for the respondents? Mr. Pame?
Yes, my lord.
No. Mr. Pame. In 2015, there were some regularizations from work charge. That we are not concerned here because he has not challenged that. His challenge is to 2013. Admittedly, in the gradation list that is there, both in the writ petition and your affidavit, these people are, except 10 and 11 or something, who were direct recruits.
Yes, my lord.
The
10.
others are admittedly junior to him.
But as per the affidavit of government, my lord.
The affidavit of the government is vague to the core of it.
Yes.
You say there was a complaint. What steps did you take? And these were for 6 months. Why, when the selection committee was there, why was his case not considered? Where is that material to show that his case was considered and rejected?
Yes, my lord. That because my lord, yes, my lord, he challenged to DPC of 2013, my lord. Now, if we go by that affidavit government, my lord, at that point of time, he was not appointed here, my lord. He was in other basin.
No, the same place. You come to page 17. Okay, why 17? We'll go by your affidavit. We'll go by your affidavit. Let us go by your affidavit. This, if you can clarify, then he may not have a case, but without clarification of that. Now, one circle, they are all in one circle under the superintending engineer of that Pasigat, Mr. Preme. They are under one circle, but in different divisions. That is what you want to know.
Circle, there is a circle is also different. Pasigat different and Jenging also different, and all also different.
Now, Jennings, okay. Now wait 1 minute. There is a gradation list here somewhere. I saw it. Yes. Page 8 of the affidavit by respondent number 1. Right?
Yes.
So he was initially in Panning.
Pangin, madam.
Right?
Madam.
Madam?
Who?
No, that's the confusion. That's what I want to clear. If you come to page 8 of the affidavit filed by respondent number 1, seniority of casual staff under Panging EM division, Department of Hydropower as on 2001. Right?
Lordship.
Here 24 is, you are referring to this affidavit, saying that he's at serial number 24, so he'll not be promoted. Now, 24 is the petitioner. Come to 49. That is R6. Right? And all have been, both of them have been handed over to Alo division. Then R9 is at page 75, serial number 75. 88 is R7, 89 is R8, 98 is R10, and 113 is R11. And he was working from 2001. R11, okay, right, direct record, we leave her. But 10 came in 2011 only, 10 years after the petitioner had come in. And madam, you come to the affidavit filed by respond number 2, superintending. You are appearing for whom?
Yes,
Superintending engineer.
yes.
Come to affidavit at affidavit file by the superintending engineer, respond number 2. He has said many things. Now come to the affidavit, which is there at as of 2016. Serial number 19, it should be 20, it has become 58, be that as it may. Right? Have you got it? 58.
Yes, 20.
It should be 20, but it should become no problem. Bikitali, still silly at Geku. So your first affidavit says as of 2001, he was in Pani. Then he is now in 2016 at Geku. Right? The others are not here because in 2013, they have already been brought to the cadre of work charge.
After 2016, he is in
Silly.
Pangin.
Where?
Because page number 20.
20?
In the 20, Annexure 7. Here in the uppermost, Lordship. Statement of casual staffs under Pangin EM division.
Department of Hydropower. So he is in Pangi.
Pangin here.
And he's still, we are still continuing in Pangi today.
No, my lord.
When?
From there, my lord, I have given the list of them, my lord.
Pasigat, and recently from Pasigat, he have gone back to Anglo again.
Fine. As of 2013, where was he?
I was
Geku.
at Geku, my lord.
These are all under the same circle or different? How are you transferring these people in this manner?
He's taking on his own, he's taking transparent.
Oh, he is the super employee.
This one.
Okay.
Is taking,
That is why you are in the complaint he has said, he's bringing in.
That's why it's very difficult, Lordship. Now, he cannot come to Pasigat and he cannot challenge the staffs there, Lordship.
That is
in 13, okay. Where is that minutes? There is a minutes drop on record.
10 and 11 respondent is also from Pasigat.
Passing. No, that is the direct record. Where is that minutes? Minutes is here.
It's also Lordship. This should be, his AC is supposed to be the upper basin, not the lower basin. He's in the upper basin. The Jenging.
All confusing.
Yes. And also 2013.
Where is that minutes? Just I was seeing it. Is it there in your repetition? Minutes?
My lord.
Minute is in our affidavit.
Affidavit. Okay.
Page number 2.
Affidavit by?
Respondent number 6 to 11.
Okay. Come to page 13. So, madam, he was in Pasigat, right? He's under Pasigat division.
He was under Pasigat division.
Okay.
After when he had come, the officer said he will
Get that. Because that statement has also to be corroborated with page 13 of their affidavit. If you see that, this is a selection wherein the private respondents have been given that workchas thing, and you see the people who are there. Pasigat EM Division Head Assistant, AE Geku, AE Pasighat, Taba Pasighat.
Lordship, they are being called in this one, while they sit for threat.
But
Threat test.
in this gradation list, this on the basis of which you did it, therein the name of the petitioner was very much there. 2013.
13, but Lordship, if your Lordship come to my affidavit of respondent number 2, Lordship, here the challenge of appointments made in 2013, this threat has stated on Lordship 2013, that is. And then Lordship can see my annexer to performance report also.
I got it, but where is that consideration of that by the selection committee? Selection committee minute does not reveal. Selection committee minute only reveals that whoever's case, we have got all the documents we have considered.
And because Lordship.
Page 17 of that affidavit, madam. Page 17 of your annexure 5. If some instruction is to be required, how long will it take for you to get it? Can you get it in day or two time?
No, I can get it. They are here only, Lordship, but then.
You come to page 17.
Of Lordship, private respondent.
No, to your affidavit. Based on the recommendation, so-and-so following members reassemble the so-and-so on the panel list, either they have not submitted requisite document or partially submitted. After thorough scrutiny, some of the so-and-so, for which the board decided to reconsider the earlier recommendation and recommend a new list due to consideration by so-and-so. So now, where is that list? Wherein, or the observation that his case was considered and rejected. Your case was never considered.
Madam.
Your case was never considered. The others were.
Yes, that is that. Madam, may I just clarify one thing, madam? Madam, this hydropower department is divided into 4 circles, madam. There is one basin circle, this is Siang Basin Circle, that controls the whole division at Alo, Pasigar, and even this Eternal Milo. This is Siang Division Milo. So therefore, no, this Siang Basin Division Milo, the headquarters is Jaiging Milo. From there, Milo, there are many division and subdivision and sections are there, madam. I have been transferred here, madam, as my friend is trying to project that I am, I do have the patronage of this, some leaders, my lord. Not that, my lord. If at all I had that patronage, my lord, I would have been considered, my lord.
That is beside the point.
Yes, madam.
Now both of you satisfy me that on the date when the private respondents were considered,
my lord,
you were also there.
Yes, ma'am.
In the zone of consideration. That much only.
I was there, my lord. There is one document.
Madam, you understood what I mean?
Yes, Lord.
Get that instruction in writing.
My lord.
I'll pass an order. Just get that instruction in writing, then we will proceed with the matter.
Lord, here in one of the.
Madam, it's confusing.
I got this morning is that a seniority list wherein his name included, the petitioner's name included, were maintained by the Jaingun Circle, Upper Siang Basin. As such, he should have continued his case against the SC.
That is the stand in your affidavit also. Madam, you get this clarified because some confusion is there. If his case was considered, required to be considered one, considered then then we will dismiss. But if not, he will have to be given this benefit from the date the private response. I'll not touch the private response, but he'll have to be given. Third, the learned counsel for the parties. So, Miss Ete Learned, you are government advocate appearing for the respondent number 2, right?
1 and 2, Lord.
Government advocate appearing for the, you are additional senior government advocate.
Yes, sir.
Additional senior government advocate appearing for the respondent number 1 and 2. Prays that she be given 2 days time to place before this court the posting details of the petitioner and the respondents number 5, 6, 7, 8, 9, 10, and 11 on the date when their cases were taken up for consideration for upgradation as work charge employees against work charge posts in the year 2012 and 2013. 12, there is one. That was that your affidavit itself says. You come to the second paragraph. Come to the second paragraph of page 17. Have you got it? Although after thorough scrutiny, some of the so-and-so could not produce record, for which the board decided to reconsider the earlier recommendation made. White so-and-so dated, update लिखिए 2012 लिखा है ना, 28/12/2012 and 22/3/2013. You got it, ma'am? Did you get it?
This page, no?
Page 17.
Yes, Lord.
Second paragraph.
28/12/2012 and
Ah.
recommend a new list.
And re-recommend a new. So there was a list earlier to that. I want how you have prepared this list. What there has to be a gradation list for that. You maintain a gradation list. Get that on record. So the written instructions shall also contain as to how the selection committee / screening committee / DPC had considered the had identified the persons who would be required to be so considered for upgradation as work charge employees in its meeting held on 28/12/2012 and 23/3/2013. Registered to list this matter again on Thursday. If there is something we can do for him, we'll do it. Otherwise,
Yes, Lord. But then only that the problem is
because
that,
there is a confusion. I understand. He may be he may be the worst of an employee, pain to everyone. But the issue is your criteria is also performance. A performance report is required. If you had considered him and then rejected, that would have been the end of the matter. But I don't find that. That's the problem. Okay. 24.
Maybe on 19.
On the prayer of this week. 19. I'm not going to take that risk.
And then 18.
No. Next, after vacation. I can't read it once more. No, I've read it. Third day, on the prayer made by the learned counsel for the year. You are appearing for?
For the appeal.
So and so. Raised it to list this matters again after the ensuing vacation.
Can we?
एक second open. Harassment of a girl, of your own daughter. That case?
That is the allegation.
After 4 weeks.
All right.
I've read it once. I don't want to read it again this week.
With the liberty to approach trial court.
Charge sheet has been filed.
Yes.
Hmm?
It's been pending. We have taken steps on respondent number 2 as well, but there's no service report. So
Mr. T.
Yeah, sir.
That's so. Learned counsel for the applicant submits that. When was the charge sheet filed?
I'm not aware of that.
Submits that. He may be permitted to withdraw the present bail application with liberty to move the trial court.
Yes.
Prayer accepted. Prayer is not objected to by the learned additional public prosecutor. Full stop. Prayer is accepted. Bail application stands disposed on withdrawal with liberty as prayed. Registry. None appears for the parties even on second floor. Registry to list this matter again on Wednesday. Woodburn. That's over. Mr. Soikia, after the last date, there was a development. Mr. Tara has assailed an order passed by the state. No. State assailed has passed or has filed a petition assailing the order passed by the state chief secretary, appellate authority. Now, all these actions are taken under your Arunachal Pradesh local bodies, defection, prevention of defection, whatever it is, 2014. Now, who is the authority therein? Defection is not automatic. There has to be an order passed. In the Panchayati Raj, that 2003, it's the deputy commissioner. Here, who is the authority?
Here is the State Election Commission.
So, State Election Commission is the authority to pass an order that, see, this either merger 4 or 3, whatever it is, against that an appeal lies. So today, Chief Secretary is staying that order. They continue as a councillor, right? Their continuation of councillor till the appellate authority finally considers the matter, cannot. But the issue would be that if he is in the cloud of defection, what would be the effect of that in a no confidence motion? That's what you are trying to project. Mr. Tara, when have we fixed the other matter?
Tomorrow.
Tomorrow. We'll have it tomorrow along with that matter. Right? If we are satisfied in that matter that a stay order has to be passed, then this matter can be considered. Otherwise, you satisfy me on one thing, that when something is under cloud in this manner, I've been trying to find out, there is a Karnataka case, Karnataka Assembly case, but I've not been able to lay my hand on that, subject to correction.
Yadurappa case.
No. Before that, Justice Ramanna, or even before that, wherein I think this issue, some persons were submitted resignation. Whether it's Karnataka or Bombay, I forgot.
No, but that is Rajendra Singh Rana case, 2007.
No.
That UP wala case.
No. Thereafter.
Okay.
Thereafter. Try to lay your hand. Because I forgot to carry my
Orissa would be
my data bank this time, books, where I note. Just try to find it out.
Orissa, that Utkal Parida.
And Mr. Tara,
My lord.
Tomorrow come prepared for the thing, whether in absence of a provision, the appellate authority cannot pass a stay order. Because I told you that day also, inherent power has to be looked into. See, you are looking it at one angle today. Today you are looking at from the angle of a person who has been held to be not eligible to be disqualified. Tomorrow, think this case from an angle of a person whom the state commission holds that no, he is not eligible. He prefers an appeal. Do you get my point? And thereafter, the chief secretary, say after 2 months of hearing, comes to a conclusion that no, he is required. So for this 2 months, a democratically elected man is kept out.
That two hats theory.
2 hats or 5 hats, I don't know. But when this court is considering, we'll have to factor in that factor also. Saying that the rule does not give, need not be. And Mr. Soikia, you also try to find some judgments on that. Do you get my point? You will get judgments, try to research with regard to Income Tax Appellate Tribunal. Income Tax Act. I'm just trying to put it so that you can put it in perspective. Income Tax Act. No, I forget. 251 or something, 250 or 251. Therein, provision for stay is not there.
Yes.
But there are Supreme Court decisions which says that in spite of that, the tribunal can pass stay orders. I think there were 2 lines of judgments. Just check up. I'm sorry, I'm not in a...
Power to issue, power to rescind. That.
And try to factor in the General Clauses Act, which says power to appoint also has the power to dismiss and suspect.
That's section 20.
Because this case will have far-reaching consequences.
Yes, exactly.
Because I've not been able to lay my hand with my limited thing which I had on any decision on this point. And Mr. Tapin, another factor which I would also like to be educated is, I'm using the word educated deliberately. Your that act says, and I'll require a copy of that act. The act says that for giving effect to the provisions of the act, the state would make rules. But no rules I could lay my hand on. Has any rule been made, Mr. Among any rule been made in that?
Exactly, but there is guidelines.
Guidelines. That will do. That will do. That will do. Because the last paragraph of that act, section of the act says,
Section 7.
7 says that you will make a rule. And in the act, it is not the appellate authority is there, but who would pass the order? Not specified. So we will have to deem it that it would be the State Election Commission. So homework for tomorrow.
May I pray kindly take up this matter in the top of the afternoon? I have some difficulties around 3 o'clock.
Around 3 o'clock.
3 o'clock.
कल कितना मैटर आएगा? 20. We'll do one thing. You're going by 3 only.
3.
Okay, we'll finish it up before that. Just remind me in the morning, because I can't tell you what would be the position tomorrow. Just remind me. All of the parties are there. We'll take up the matter. Mr. Soikia, Mr. Pang, Mr. Tara, Mr. Tapin, please just try to examine this. Interesting question.
Yes.
Just try to examine this aspect.
My lord, just after motion item, my lord, it would be grateful, my lord.
Don't worry. Just make a mention in the morning. Along with your
friends, and I'll request all of you, please, just after motion item. I'll take 20 minutes time. I have my written arguments. I'll share all of you.
Today you share it.
I can say.
Along, there's another matter listed tomorrow, so we'll take it up.
That
Take.
much of it.